You ever watch one of those courtroom dramas and just marvel at how the lawyers pulled a perfect case-winning answer out of a witness? Well, I'm here to tell you, it's not magic. It's a skill, a really refined one. And today, we're going to pull back the curtain and break down the real-world techniques lawyers use to guide testimony and build their case, one very precise question at a time. So picture this. Your entire case is balanced on this one tiny detail. Your star witness is on the stand, the pressure is on, and suddenly they draw a total blank. It's pretty much a lawyer's worst nightmare, right? But it happens all the time because, human memory is not a hard drive. So what on earth do you do?
All right, so here's our game plan. First, we're going to tackle the big problem, memory itself. Then, we'll get into the lawyer's toolkit, how they can legally jog a witness's memory, and even the risky business of asking a question when you're not 100% sure of the answer. And finally, we'll see how it all ties together in the search for truth.
Okay, first things first, we have to get this straight. Giving evidence in court is not a memory test. It's not a game show where you have to have perfect recall. Everyone in that room, especially the lawyers and the judge, knows that the stress of a trial makes it incredibly tough to remember every single detail perfectly.
And because of that, the whole legal system has actually built-in procedures to help witnesses tell their story as accurately as they can. Now, these aren't some sneaky loopholes. They're basically safeguards, put there on purpose to account for the fact that we're all human and our memories get fuzzy, especially under that kind of pressure.
So what's the first thing a lawyer can reach for when a witness's mind goes blank on something important?
Well, it's a formal technique, and it's called memory refreshing.
And let's be clear, this is not about feeding a witness their lines. It's a real legally defined process. Under a specific law, the Criminal Justice Act, a witness can actually look at a statement they gave way back, closer to when the event actually happened, when their memory was fresh, to help them remember the details in court.
But you can't just do it on a whim. A lawyer has to lay the groundwork very carefully. As you can see, there are steps. First, they have to establish that yes, the witness made a statement earlier. Then, they get the witness to confirm that the statement was their real memory at that time. And then, they get them to agree that, yeah, their memory was probably a lot better back then. It's only after all that they can turn to the judge and ask for permission.
So let's see how this actually plays out. Imagine there's an assault in a pub. The type of glass used as a weapon? That's a huge detail. The lawyer leans in and asks the witness on the stand.
And nope, the witness just can't remember. This is that moment. The critical fact is just fading away. This is where the training really has to kick in.
So the lawyer does their thing, gets the judge's permission, and then directs the witness right to the original statement. The witness reads it over, quietly, and you can practically see the gears turning, the memory clicking right back into place. And boom, there it is. The memory's refreshed, the evidence is now officially on the record, and the case is back on track. It looks simple, but its power is all in the precision.
But you've got to be careful with this tool. A lawyer can't just keep going back to the well. If they use it too much, they might make their own witness look, kind of unreliable, like they can't remember anything without a script. Plus, the judge can just say no. It's a powerful move, but it takes some serious judgment to know when to use it. Okay, so if memory refreshing is all about sticking to the script, our next technique is about knowing when to just throw the script out the window. And it means breaking a rule that you've probably heard 1,000 times.
This is probably one of the most famous pieces of advice for lawyers out there. It's practically gospel. The idea is to stop you from accidentally asking a question that gets an answer that completely blows up your own case.
Except, it's not exactly true. Actually, sometimes the absolute best, most convincing details come from asking a question where you don't know the exact answer.
Check out this example. Your witness says they overheard a key conversation. Okay, fine. But to make that really believable, the jury needs to feel how close they were. So a good lawyer might take a calculated risk and ask, so how far away were you? Now, they don't know the exact answer, but they know their witness did hear it, so the answer's probably going to be good. If it is, boom, you've just added a powerful, spontaneous detail that feels totally real.
So all these little tools and techniques, they're all part of a much bigger skill, controlling the story, controlling the narrative. And this, right here, is where you can see the huge difference between a rookie and a real pro. This slide lays it all out. Rookies, they ask these big, open questions like, so what happened next? And that just lets the witness wander off. Pros, they use short, sharp, single-fact questions. The classic,
who, what, where, when. They stay in control. Rookies also react to every single answer, okay, thank you, which just clutters everything up. Pros, total poker face. They let the answers speak for themselves. But the biggest difference is that pros listen and they adapt. Amateurs just cling to their script no matter what.
Because at the end of the day, it's all about structure. As the experts teach, a lawyer's job is to be a guide for the witness and for the court, leading them through the whole story in a way that's clear, that makes sense, and is just easy to follow.
So, why do we have all these rules and techniques anyway? It's not about playing games. It's not about tricking anyone. It's about something much more important. It's about finding the truth.
So here's the big takeaway. All of this, memory refreshing, those calculated questions, controlling the narrative, none of it is about pulling a fast one. These are tools designed for one single purpose: to help the court hear the most accurate, the most complete evidence possible. And that is the absolute foundation of a fair trial.
Which leaves us with a pretty big question to think about. If a huge part of being a lawyer is being a master storyteller, then how much of justice depends not just on the raw facts, but on how skillfully those facts are told?